Lewis, and I am an attorney with the Fuchsberg Law Firm. My associate Carly Giannetti and managing partner Alan Fuchsberg to my left. We're here today because last evening we filed a federal complaint against Cabot Oil and Gas Corporation on behalf of 15 families on Carter Road. We call them the Carter Road 15, who as a result of Cabot's negligence, they have suffered contamination of their water, loss of property value, permanent damage to their property, loss of use and enjoyment of their life, loss of the only thing that these people had for the next generation of this community. Unfortunately, these people came together because they did not have the faith in the company that they would do what was necessary to meet certain contractual obligations with respect to repairing any damage that's been done. It's obviously a contention of ours that the damage is permanent. Therefore, we have filed the suit. We're attempting to acquire the remediation to the extent that it can be provided. We're suing for compensatory damages. We're suing for breach of contract. We are suing for fraudulent inducement and solicitation. And I'll stop there. And Alan, anyone else want to speak?
One of the core issues here is that the water supply, the drilling was done in a negligent manner without proper plans and without proper engineering plans, and time after time they have drilled either too close to the water supply or penetrated through the underground water supply in such a way that they have permanently contaminated the underground water supply, so that gas, the gas that they're seeking out from the ground now flows into the water supply, and none of the drinking water is usable. In addition, the gas is highly combustible, and there has been one explosion at a home, in addition to things that have happened at the wells, and nobody can use their drinking water. They were never told that this was even a possibility that it would happen. Some people in signing leases signed leases because they were told everybody else has signed leases. If you don't sign leases, they're going to be going under your ground anyway. They were not, and then when they reported these problems to Cabot, in many instances Cabot took a long time to do anything and in fact ignored them. In addition to the gas going into their water, they now have ground surface contamination of bacteria in their water because of it's no longer secure and pure, and their water had in many instances been tested before this drilling started, and they did not have these problems with their water. Their water is filled with odors, their water is unusable, their houses, except for perhaps bathing, but then very, very uncomfortably, their clothes smell if they're washed in it, and their land values are destroyed. And none of this, to the contrary, they were given reassurances that this was nothing, this is the new generation of clean energy, and that they were not being exposed to any of this. None of this was explained to them. What we're talking about has been, in fact, confirmed by the Pennsylvania Department of Environmental Protection, which has gone out and investigated and concluded similarly that the drilling was not done in accordance with proper engineering standards, so that when they do these drill holes, they did not seal them in such a way so as to maintain safely the water supply. It's our client's contentions that Cabot comes in here, takes its gas. They don't have to worry about generation after generation. They'll be out of here in 10 years. or so, but these people are here for the rest of their lives, and so the focus is very different. The Department of Environmental Protection just cannot keep up with the problems that are happening. There's been over 60 wells already. There's another 60 wells planned or so in the next year. In addition to everything that we've been telling you, there have been a number of significant spills of fracking fluid, of benzene, all of which are carcinogenic and toxic onto lands. Trucks let fluid seep out of them. There have been many accidents as when they drill, they use a fluid that is a kind of
A toxic cocktail.
is a toxic petroleum mix that helps them penetrate the rock that they have to get through in order to get down deep to the oil. It lubricates and they put it on great pressure, and there have been quite a number of spills. They bring it in by truckloads. Then they take the waste materials and they put them in holding tanks that they've built. They failed to line some of the holding tanks. The holding tanks have seeped through. I mean, the operation has been full of negligent steps, one after another, that really do not take into consideration the fact that people live here for generations, that this is their land, this is their beautiful environment. And it wasn't enough to just go to Cabot and say what's happening here because they're ignored. And perhaps you have some questions for some of our clients.
Well, I have a question for you. The way you read the consent decree that Cabot signed off on earlier this month, do you read it as Cabot taking responsibility and admitting that they allowed gas to escape into the water supply?
What we take that consent order to mean is that the DEP found such. The DEP.
But Cabot
has
had to sign
concluded.
off on it, correct?
Cabot signed off on it. That's correct. They signed off on it. They have omitted agreement to key portions of the consent agreement with respect to statutory violations, for example. The emphasis from plaintiff's position is that consent order, as it should read, as to mean that, as far as the regulatory body that is to control oil and drilling operations, found the causation for the pollution to be the activities as specifically enumerated in the consent agreement.
How could they be signing this consent and agreement unless they are acknowledging DEP's findings? I believe, and I think it's common sense, that if they could disprove DEP's findings, then they would have disproved DEP's findings, and they would not have acknowledged by signing a consent agreement to change their practices. They would not have signed something that had such serious findings in it. I think for legal purposes, they're saying this is not an admission on our part.
That's what I wanted to say. Unlike our clients who are sitting here, they didn't have attorneys by their side. They were, when Cabot came, announced in the late afternoons or evenings to solicit leases. My point being that was a negotiated element of the consent order on Cabot's side. They had no choice but to sign it in order to continue to drill.
The consent agreement, I believe, pertains to gas contamination, correct?
Correct.
Rather than contamination by fracking fluids.
No, the consent agreement, and there have been a number of violations imposed, have been for spillages of fracking fluid, and that is also contained in that consent agreement. Acknowledgement, for example, there were three major spills within a 10-day period alone.
Right.
And there are other spills as well. And not only that, but that consent agreement is the second order that has come out from the DEP. There was one in September that required them to take remedial steps that were not undertaken. And were given, had a lesser fine in September, and now a more major fine.
Still a slap on the wrist.
Which just goes to show that, Cabot is not taking on its own seriously and conscientiously the